Secured transactions, liens and security interests. In all 50 US states, Article 9 of the Uniform Commercial Code, the UCC, governs secured transactions, where security interests are taken on personal property. This applies to all forms of movable property, tangible property and fixtures. Mortgages and other loans involving real estate interests are regulated not by Article 9, but by real property laws that vary among the states. Under the basic rules, the lender takes a security interest on property belonging to the borrower via a security agreement. If the borrower defaults on payment, the lender has a right to take the property, retain it, or sell it to repay the debt. The lender must first go through a legal process of perfecting the security interest. In some situations this is automatic, but sometimes requires a filing. If the proceeds of the sale of the collateral property are insufficient to cover the debt, the lender takes a deficiency judgment against the borrower. This allows the lender a separate legal action to recover the deficiency remaining after the sale of the collateral. The general rule is that a written security agreement is required to create a security interest. The written security agreement must identify the property, contain the promise to pay and the terms of payment, define the lender's rights on default, and it must be signed by the borrower. Like a contract requires consideration, the security interest requires value. Anything forming consideration in a contract would form value in a security agreement. There is an exception, and a writing is not necessary where the lender holds the property as collateral. So a pawn shop holding the property would not require a writing to create a security interest. The handing over of the property creates the evidence of security interest required by the court. Perfection establishes the right of a secured creditor above other creditors claiming an interest in the collateral property. There are three methods of perfection. The first is possession. If the lender, like a pawnshop, holds the collateral, this acts as perfection and no filing is required. No filing is required for lenders providing the purchase money to acquire consumer goods. This applies to consumer goods, not commercial or business assets. Otherwise, perfection involves lenders filing a financing statement with the county clerk or the Secretary of State. In some states the filing is with the county clerk, in others it's with the Secretary of State. The financing statement is a public record forming constructive notice to others that the property is subject to the security interest, and the financing statement is good for 5 years, after which it can be renewed via a continuation filing. The perfection priority rule settles disputes among several lenders when each is claiming a security interest in the same collateral property. Perfected claims beat unperfected claims. First to perfect beats later to perfect. Secured but unperfected claims beat unsecured claims. So lenders are advised to secure their claims with a security interest, then perfect their interest as quickly as possible if they wish to win a dispute against other lenders. However, there are exceptions providing priority to liens held by mechanics, attorneys, and other artisans. A fixture is personal property that's attached to the real estate. Fire sprinklers, light fittings, and other pieces of property become fixtures when they're attached to the real estate. The test is whether the property enhances the value of the real estate. If it does, it's generally a fixture. A mortgage lender holding an interest in the building and a lender holding a security interest in a piece of personal property such as a furnace, can sometimes dispute which one has priority rights when the furnace forms a fixture in the building. The general rule is that the fixture is considered part of the real estate, and the mortgage lender wins the dispute, claiming priority rights over the fixture when the borrower defaults. However, there are some exceptions. The real estate mortgage lender loses the dispute, and the lender of the furnace wins, claiming priority when it provided the purchase money to buy the furnace and the security interest was perfected by a fixture filing within 10 days of the date at which the furnace was fitted and became a fixture. The real estate mortgage lender also loses the dispute if the mortgage or lien resulted from a lawsuit after the furnace lender's security interest in the fixture was perfected. Another exception involves fixtures that are readily removable machines or appliances, such as washing machines, where the security interest was perfected before they were attached and became fixtures. On default by the borrower, the lender has a right to repossession of the collateral property. The lender is, however, required to act in good faith, with commercial reasonableness and reasonable care to preserve the collateral. Unless the borrower presents a written objection, or the matter involves consumer goods that are more than 60% paid for, the lender has a right to retain goods in settlement of the outstanding debt. Alternatively, the lender can sell the property to satisfy the debt. The sales process must involve an auction or an alternative process that meets the standard of being commercially reasonable. If the proceeds of the sale are insufficient to pay the outstanding debt, and the security agreement allows, a deficiency judgment gives the lender a right to bring a personal action for recovery against the borrower.